Welcome. Today I'm going to be talking about trademarks, specifically in regards to the 1999 case of Coca Cola Company and All-Fect Distributors Ltd. This case was an appeal against a decision made by Justice Merkel in the federal court, who refused to grant an injunction restraining All-Fect from distributing their cola lollies. The appellant, Coca Cola, were the owners of several registered trademarks in Australia. This contour bottle had been manufactured and traded since 1938 and was readily recognised by its shape to Australian consumers. This is the two-dimensional drawing of the distinctive contour bottle design that was registered under the 1955 Trademarks Act in Class 32. The respondent, All-Fect Distributors, was an importer and wholesaler of cola-flavoured confectionery. This product was a similar shape to the contour bottle design and featured the word cola. This picture reflects the shape of the cola confectionery when pressed flat. When the Coca Cola Company commenced court proceedings, they claimed the respondent's confectionery infringed several of their trademarks. They made claims in regards to passing off and misleading and deceptive conduct under the Trade Practices Act. At first instance, Coca Cola was unsuccessful. The primary judge found in favour of the respondents. The contour bottle design mark was the main issue in the appeal, with Coca-Cola claiming that the importation, promotion and sale of the cola confectionery was an infringement of their registered trademark. The real question was whether the distribution of the confectionery infringed the contour bottle design under Section 120, subsection 3 of the Trademarks Act. Coca-Cola had to first prove that All-Fect had used the contour bottle shape as a trademark. Secondly, this use would likely be taken as indicating a connection between the cola confectionery and the Coca Cola Company. Use as a trademark means the use as a badge of origin that links the goods with the person who applies the mark to the goods. The trademark could not be the good itself. However, it was held that the mark could cover the whole of the side of the product. The silhouette, fluting, and label of the lollies was considered distinguishing features, constituting use as a trademark. Whether a mark is deceptively similar depends on whether it so resembles another mark that it is likely to cause confusion to customers. These two designs had several similar features, such as curved sides, a top and bottom portion with longitudinal fluting, and a central portion without fluting. The word cola, although not a trademark, was also found to reinforce the link between the confectionery and the Coca-Cola beverage. The colour of the confectionery was also another similarity. As such, the cola confectionery was found to infringe Coca-Cola's registered trademark. Hence, the full court allowed the appeal. The matter was remitted to the primary judge for further consideration of a defence under Section 120, subsection 2, whether the use of the sign was not likely to deceive or cause confusion. The primary judge was also ordered to reconsider the passing off and misleading and deceptive conduct claims under the Trade Practices Act. So what was important about this case? The full court followed the traditional view that a trademark could not be the product itself, which is supported by the 1955 Trademarks Act. It also confirmed that the Act provides for the registration of shapes. Although Coca-Cola could not trademark the contour bottle itself, they did successfully register a trademark over the two-dimensional drawing of the contour bottle design. Where the shape is used to distinguish the goods of a trader, and consumers connect the goods of that shape with the manufacturer, the shape will act as a badge of origin and is a registerable trademark. Registration helps to ensure the owner has exclusive rights in Australia and to protect against infringement. Thank you for listening.